Hello, everybody. My name is Joanne Thomas. I'm Programme Manager for Innovation and Intellectual Property at Manchester University NHS Foundation Trust, or MFT for short. And today I'm going to talk to you about what does intellectual property have to do with you. I'm going to try and make it a little bit interactive as well as we go along. So I think it's always helpful to understand a bit about a speaker's background. So, for your information, I started out doing clinical trials. I've always worked in a hospital. After I did clinical trials for several years, I went into NHS R&D management. But most of my career has been as an NHS intellectual property advisor, based at MFT and Central Manchester before that. And my role is to help NHS organisations and NHS staff to identify their intellectual property, understand who owns it, understand how to protect it, with the view of helping them to share it with other NHS and other organisations as appropriate to benefit healthcare. Sometimes that can be sharing freely, and sometimes that can actually be commercialising. I'm just going to hide that. Um, so in terms of what I've done, I thought I'd give you a few examples so you had a bit of an idea. So the first thing on the left, Sage and Time training, that's communication skills training at foundation level, so it's suitable for anybody. This was developed at South Manchester many years ago now, and I've been the business lead for about 14, 15 years. And we basically have protected the intellectual property around the training materials, created a trademark, and we run a train the trainers program and license all of these organisations on the map to actually run Sage and Time training for their own staff. My second example in the middle is the VitaliJack cough monitor. That one I've worked with the researchers, so clinician and a software engineer, and the company VitaliJack. And we have worked on a research tool monitoring coughs, and they are soon to launch a clinic version of that. And then on the right hand side, just something very different. I worked with a surgeon, an orthopedic surgeon, and the two guys in the photo are engineers, and they developed what it looks like a roll plug, which is an anterior cruciate ligament fixator, so it implants in the back of the knee. And we licensed that to a company in America, Arthrex, and that's a photo of us winning an Impact Award with Maggie Philbin from Tomorrow's World presenting it. So what am I going to talk about today? Well, I'm going to go over the reasons why you need to understand intellectual property, what it is and how it can be protected, who owns the IP that you create, and what to consider when you're creating stuff with other organisations, and also what you should consider when you're using intellectual property that belongs to other people. And I'm going to try and use a few case studies throughout my talk. I've had to anonymise them quite a bit, but hopefully you'll still get the essence of them, because a lot of them are sort of what not to do. So we're going to start with a poll. And we're going to use Mentimeter. I don't know if any of you are familiar with this. Sophie is going to take control of the screen. You can either access it on your computer or probably more easily on your smartphone. If you type in menti.com, and then once you get to that web page, if you enter this code, then you should be able to see the first poll. So Sophie, can you take over? So my question to you is, do you create any of the following? Documents and reports, PowerPoint presentations, software code, recordings or videos, website content, data, or promotional materials? So I know you're all trying to get onto it at the moment, but if you can then vote, that would be great. Fabulous. Okay. So variety of things. I'd expect quite a lot on the first two, documents and PowerPoint. No software, interestingly, but there is some on all of them. Okay, that's great. Thank you, Sophie. So I will just share my screen again. might take a while again for it to load back. Can I have a thumbs up that you can see it again? Fabulous. Okay. So that was the first poll. So the reason I was asking you that is because all of those things are intellectual property, and I'm hoping that everybody on this call today answered yes to one of those. I'd be really surprised if you didn't. So what is intellectual property and how is it protected? So intellectual property is defined as the output of creative or intellectual activity. So it's basically something where you're using your brain. It has an owner, like any other form of property, and it can be bought or sold or given away for free. Again, just like property. And so if you think about it like a house, you could sell your house, you could rent out one room of your house, you could rent out several rooms, you could allow people to paint the rooms or not paint them. You can have different rules for different people. And it's the same with intellectual property. And different types of IP have different types of rights that actually protect them. And when I'm talking about protecting, it's about stopping others from using them without your consent. So in terms of examples, we've seen some of them already. So documents, reports, papers, surveys, software and apps, websites, lab tests, medical devices, just the knowledge, the expert knowledge that you get over time, whether that's technical or clinical or something else, data, films, diagrams, photographs, presentations, sound recordings. And obviously, this is a non exhaustive list. But as you can see, from an NHS perspective, we generate lots of these every day. So, how can it be protected? So this table sort of gives a summary. I'm not going to go into a lot of detail today because this session is kind of a beginner's guide, but I just wanted to give you an overview so you had the basics. So in general, things written work, so like documents, but also software code, presentations like this one, drawings, films, sound recordings, websites, photographs. They can all be protected by copyright, which you will all have heard of. There's no application process for that, and I'm going to tell you a bit more about that later on. What people tend to think of as intellectual property or IP is inventions. So the things like equipment and devices and drugs and diagnostic tests. There's quite specific criteria on what's regarded as an invention. It has to be new and inventive, as in not obvious, and it has to be something that can be made and used or some kind of method. And that's protected by a patent, which I know you will have heard of. There is an application process for patents, and you're not guaranteed to get a patent if you apply for one. It has to fit the criteria, and the examiner has to accept it. Then you have brands. So the obvious things are words like company names and logos. What you might not know is you can also protect sounds. So the Intel inside, in fact, I've got it on my laptop, that little sticker that says there's an Intel, is it a processor inside? And I don't know if you remember the advert, it used to go do, 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 do. Well, that sound is a trademark, registered trademark, and also color. So I think the EasyJet orange, that's a registered thing. And more recently, Cadbury's have trademarked their very distinctive purple. The NHS lozenge, the NHS letters in the blue rectangle is also a good example. Designs are less relevant to us most of the time. It's physical shape and configuration and decoration, and there's something called design right that can protect that. And then the final thing, which is actually quite powerful, and a lot of people don't always think about, is your know-how, your knowledge, your expertise. And that could be some kind of idea, it could be a method, it could be general information that you know that a lot of other people don't know, or some kind of trade secret, a method or a recipe like the Coca-Cola recipe or the KFC recipe. Those can be protected by keeping the information confidential. And so that's either keep it secret and never tell anybody, or use a confidential disclosure agreement if you have to share it with somebody. And another term for a confidential disclosure agreement is a non-disclosure agreement, or NDA, which you might have come across before. So that gives you an overview that different types of IP are protected in different ways. And the reason you want to protect them is so that you can control how they're used. It's not to stop people using it, it's just so that you have some control. So why do you need to know about all this? Well, number one, you sometimes would like to use IP that's been created by others, and it's probably more common than you realise. The second thing is that you can get into quite a lot of trouble if you use IP incorrectly. And the third thing is that you need to sort out any IP issues that you have before you share the IP that you've created. And certainly in the NHS, there are a lot of times where we're sharing best practice or things that we have done, and you need to understand what you're doing before you do that safely. So it's time for our second poll. So Sophie, if you could bring that up on the screen again. And whilst you're doing that, my question to you this time is, do you work or collaborate with others, or do you commission others to provide a service or materials? So if you could vote on that, that would be fantastic. Now, what I can't see from doing it this way is I can't see what percentage of you have responded. And so what I don't know is whether any of you are answering none, because that was one of the options as well. So I think here, obviously, some of you are doing it, but perhaps not that many. If there's, I don't know what, 20 people or so in the call, there's only a few working and collaborating and a few commissioning. But even if this isn't relevant to you currently, it's likely to affect you in the future, or it might be that you're working somebody else in the future, and so you can share your knowledge. So I'm going to put my presentation back again. And then move on. So the next thing, so I've told you about intellectual property protection. The next thing is who owns the IP that you create or use. So the first thing to say is it's quite complicated. So I'm giving you a slightly simplified version here. But the first thing to be aware of is that your employer normally owns the IP that you create during the course of your employment. So course of employment doesn't mean working hours, and it doesn't mean location. Obviously, since COVID, there's been a lot more working from home. There is no actual definition of it, but that hasn't actually been teased out. So this PowerPoint presentation, it's written work protected by copyright. I've done some of this in my own time, but it's related to my work. So my employer, MFT, will still own the copyright in that. If, however, I was writing a novel, I don't know, Mills and Boon or something like that, then because that isn't related to my work in any way, then MFT wouldn't own that. So that's the first key thing. The second thing is that, and this is kind of not what you would expect, but just because you're commissioning work, just because you're paying others to provide something to you, a service or a product, even if you're giving them the brief and you're actually giving them the money, it doesn't necessarily mean that you own it. And I'm going to unpick that in a bit. And then the third thing is that when you're collaborating with others, which obviously is really common in the NHS, and I'm sure it's even more common with you at NHSGM, is that you can end up generating jointly owned intellectual property. And I'll talk a bit more about that later. So looking at your employer, first of all, it might seem really obvious, but again, in the NHS, it's not always quite as clear cut as in some other industries. So when I'm talking about your employer, I'm talking about the name of the organisation on your wage slip or your salary slip. Now, I'm aware that some people often get funding from another organisation. It could be Health Education England, or it could be some other grant, or it could be some other thing that you're working on. But unless there is an agreement between the funding organisation and the employing organisation, it will be your employer that will own the IP that you generate for your normal work. The next thing to think about is secondments. So again, these are quite common in the NHS. So here, if you were being seconded to another department within NHSGM, From in that circumstance, your employer is the same, even though you're working on a different project or have a different normal duties. So your employer still owns it, NHSGM still owns it. But if you think about it, there are some instances where the secondee goes to work in another organisation, in a host organisation. And there, if there's no agreement in place, then the employing organisation will own it, even though the secondee is effectively working as if they're within the host. And then if you think about it, then trainees, so trainee doctors, they often go on rotation. They're often employed by one organisation and then work in several others. Same principles apply as for being on secondment. And so an example I've got here is we worked with a surgical trainee who was working in a host trust but was employed by a core trust. I think it was the deanery at the time. And he had come up with some software that the host trust actually wanted to use and share with others. And the host trust actually needed to ask the employing trust to transfer ownership to the host trust so that they could actually do with it what they wanted and share with others. And that was actually agreed quite successfully and amicably. And it didn't also take that long to do. So there is some precedent for doing that, but the technicalities are your employer owns it. So if we move on then to thinking about commissioning work, so that's it could be that you're getting somebody to come up with a new website or create some software for you or an app, or they're creating some training or some training materials or some kind of guidance. Then in general, when you're commissioning, it's external, it's an external organisation, so they will have a different employer to you. So it then doesn't matter whether they're working on your site or off site. You won't necessarily own the intellectual property that they create, even though they're working for you on your project. You need to check the contract to see if it mentions intellectual property and see what it says about ownership. Some instances, some companies do have clauses in their contracts saying we'll transfer the ownership to you once you've paid us, which is fair enough, but it's not always the case. And if it isn't mentioned, then all you have is a license, like permission to use it. It's an implied license to use it for the purpose that you told them about originally, and they can still use it for other things as well. So, there is an action here to go and check your contracts if this is relevant to you. And I wanted to mention an example that came across a few years ago now. It was an information system that was generated by an NHS organisation. And they had some external contractors, some experts, create the information system alongside some internal staff. And they came to us because they were looking to roll it out to other organisations and wanted some business and some income generation advice. What we found when we were looking at it was the contractor agreements didn't mention intellectual property at all. So the contractors owned the bits of the system that they had created. And when they got wind of the fact that the NHS wanted to generate some income from it, the contractors asked for actually quite a large sum of money to transfer ownership to the NHS organisation, and it just wasn't feasible, and so it didn't go ahead. So there can be some quite serious implications if you don't get it right. So I've talked about working when you're commissioning, so you're very much the boss and they're doing the work. What about when you're collaborating more, where it's a bit more of an equal relationship and you're all working together? Well, some of you will know we're not one NHS from a legal perspective. Each trust, ICB, GP practice, etc., is separate. It's a separate legal entity. So they will all own the IP that their employees create. And then, of course, in the NHS, we're often collaborating with other organisations as well, universities, third sector, companies, and it's pretty common. I mean, I see so much there's collaboration going on, and that's because it's really effective and it makes significant improvements or creates things that are really helpful. But in these instances, when you've got several people from different organisations working together, the intellectual property that's created will be jointly owned. Now, joint ownership is messy and it's not recommended. And it's not just us saying it, it's not like our personal preference. This is a general principle. that it's not advised. It's much better for one organisation, and there normally is a lead, to take ownership, to take control and ownership of the intellectual property and manage it on behalf of everybody else. Um, if that happens, the other collaborators, they can still be acknowledged for their contributions. They can still be given a license, which is permission to use it for their own internal purposes. And if it's something where there is going to be sold and there's going to be money generated, then they can still get a share of the revenue that comes from that. And so what we advise on any kind of collaboration is to have some kind of agreement in place to cover off intellectual property, ideally at the start, but there have been many instances where we've gone back and put it in place retrospectively. And so that is possible. It's just a bit messier. So let me give you a couple of examples of things where it's been tricky when there's been sort of collaboration and joint IP ownership or IP ownership issues in collaborations. So the first one was there was a patient guide that was developed in a trust for a university project. And as you know, trusts and university staff work very closely together in a lot of instances to try and come up with new things to improve patient care. And the university had got the funding for the project. The university had collaborated with the trust, asked them to create this patient guide that was being assessed in the research. Unfortunately, the collaboration agreement said that the university would own all the intellectual property that came out of this project, which meant that the university owned the guide, even though the trust had come up with it and it was the trust's knowledge that was able to create it. And so the trust couldn't actually use it with its own patients without getting permission from the university first. So it was possible to rectify, but it wasn't ideal. Another example I've got is, and there was a resource that was generated by two NHS trusts. And so there was joint IP ownership. One wanted to sell it and one wanted to share it freely. And because they couldn't agree, because they're joint, they both have to reach agreement before they can do anything. So they weren't able to progress it either way going forward, which was a bit of a waste of that resource that could have benefited others. I've got another example, which is to do with working with the company. I mean, this isn't specific to working with industry, but this was a nurse who was developing some training for surgery, actually. And she'd planned to collaborate with the company that provided some of the surgical supplies. She had a really good relationship with them, worked with them over many years. They had some training materials. She wanted to use those and then build on them and create some extra stuff to create like a whole program. And they said, yeah, that's fine. So she gained the funding, and the funder then asked lots of questions about intellectual property. And when we started to look into it, what we found was that the company was only happy for its own customers to have access to the materials it was contributing to the programme. And not all of the NHS organisations that were going to be involved in the project or nationwide were current customers, which meant it couldn't have been used for any organisation. This conflicted with the funders' terms because the whole point of the funding was to test this training, and if it worked, then roll it out nationwide to benefit the NHS. So there were huge project delays because there was this issue, there was lots of disagreement. And the last I heard, and we were in communication probably for at least 2 years, they were unable to reach agreement. And this would have been avoidable if they'd had a discussion about IP at the start and discussed the plans fully, so we could have worked out what these issues were and then perhaps found a way around them. So this is my final poll, and this is a statement. And so the statement is, you can use an image from a website as it's in the public domain. And the options are, is that true or false? So Sophie, can you put Mentimeter up again, please?
I'll just wait till everyone has joined, and then I will
Fabulous.
press enter.
Thank you. So vote true or false. You can use an image from a website as it's in the public domain. False, pretty good. Yep, that's the right answer. And I'm now going to explain why. So I've never seen the points thing before. Okay.
Sorry.
That's all right.
Sorry to the one person who got it wrong.
It doesn't matter. The point was you participated and then you go on to learn why. Most people, I must admit, I thought more people would actually get it wrong as well, because people say it to us all the time. So the reason I asked that is because I want to talk about using IP that has been created by others. So I said before that copyright protects written work, photos, diagrams, websites, software, recordings, and so on. And that's most of the stuff that we tend to generate in the NHS day to day. So copyright, it's an automatic right. It exists as soon as you create the work. There is no need to register it. There is no need to actually put the copyright statement on, the C in the circle with the year and so on, for that copyright protection to exist. So that means that just because you see an image that's in the public domain on a website that doesn't have a copyright statement, it doesn't mean copyright doesn't exist. So before you use anything from anywhere, you need to identify the owner and seek permission to use it. Now, it may be that they'll say, yes, that's absolutely fine, go ahead. And when you're seeking that permission, you need to be very clear on all the possible uses you might want to make of it, so that you're being very transparent about how you will use it, because their terms might vary. They might be happy for you to use it in the NHS, but if you were doing it because you were working with a big drug company, they might say, well, actually, we want to charge them if they're going to be having access to it as well. So sometimes you do have to pay license fees. It's quite common if you're using some surveys or questionnaires that have been standardized and validated to have to pay a fee. It also means then that when you're creating stuff, you should really add a copyright statement to your own work to make other people aware that the copyright protection exists, and also who owns it, so that if they want to reuse something, they know who to come to. So I've got another action for you, which is to check if your resources contain IP created by others, and if so, then seek permission. So I've got some examples for you here to go through. So the first one is one that you might know about, the Virtual Workforce Information System, or VWIS. So I've been working with the team there and doing a bit of an IP review. And what we found was on some of the resources, I think it was in the One Workforce, One Model resources, there were a few photos, just the odd photo. Now, they'd been used from some kind of NHS source, so they were fine to use within NHS GM and for the current purposes. But we were looking at whether we could generate some income, whether they could be something that could be sold. And so we needed to check the source and the license terms, and we weren't able to do that. So without knowing what we could definitely do, my advice to them was replace the photos with photos or images that NHS GM owns or has the right to use. And then there was also a figure in there which was going to have copyright protection. And again, I suggested that they sought permission for that. If you think, I'll be fine, no one will know. We've had at least one instance of an NHS organisation contacting us saying, we've created a website. One of our colleagues has put an image on there that we have had a letter about, saying that it is owned by this image company and that we have to pay license fees to them. At which point the invoice is several £100s, which they have no choice but to pay. So it can actually cost you money if you get it wrong. And to give you an example of perhaps how to do it right, so the Sage and Time training that I mentioned to you before, so we have training materials. We give other organisations a licence to use the copyright material in the training materials and also in the trademark, and we charge them an annual licence fee to be able to run that training. When we're sometimes publishing a paper in a journal, often the journals want to own the copyright. So you'll see that often the journal owns the copyright in the copyright statement for papers and articles and things. And we say, well, okay, we can give it to you for all the article, but this figure and that diagram and that wording, we want to retain ownership for because we need to reuse them in our training materials. So we give them a license to use that. And that's where you kind of say reproduced with kind permission of, and it still has the copyright statement to MFT. So that gives you an idea about how you might be able to handle things. I've seen your comment, so I'll pick anything up at the end. So to summarize them, I've got 4 key messages for you. One is to be aware of the IP that you are creating, which is pretty much most of the stuff that you're doing and or using, and remember that the employer normally owns the IP that you create. Number 2 is when you're creating IP with others, and that could be whether you're commissioning them to do stuff or you're collaborating, you should put some kind of agreement in place to cover intellectual property. Number 3 is that you should seek permission before using IP belonging to others and be aware that you might have to pay. And number 4 is that if you create something that is valuable, and by valuable, I don't necessarily just mean money, I mean something that could benefit others in the NHS or beyond, then consider making sure it's protected properly, in most cases adding a copyright statement, and seek advice on how to manage it. So this is our generic email address if you want to contact us. I've got the copyright statement at the end. And just to let you know that all the images that I've used, either MFT owns or I've got them off the website Pixabay, which is brilliant, by the way. And you can get some images for free for commercial use with no attribution required. So it's a really good source of images if you're looking for presentations and other things. So I will say thank you for listening. I will stop sharing my screen and I'm happy to take questions. So Sue, did I see you'd put a comment?
Absolutely. I just want to say thanks, Jo, for doing this presentation for us today. It's been really helpful. Something that I've worked with you before, haven't I?
Definitely,
in
yeah.
this space, and I'm conscious that it's not necessarily on the radar of my immediate colleagues in this particular role. Sophie, would it be possible to stop the recording now, just so people can ask questions freely? While people have a think about, in terms of images, I think that's